when we talk about the provisions for divorce, divorce is a very discouraged thing. It falls into the category of discouraged acts in Islamic law. And there's a statement of the Prophet that says divorce is the most hateful thing to God that is legitimate, or that is legal, that is licit. The Quran takes establishes strong protections against the possibility of divorce. If a husband and wife can't resolve a matter between themselves, they're supposed to get their families involved, and the two families are supposed to get involved and try to reconcile it. This is something that, whatever can be brought to bear to bring reconciliation between a husband and wife should be brought to bear. Now, divorce rights are something that represent another differential between men and women in Islamic marriage. Men have, under Islamic law, a unilateral right to divorce. A man can divorce his wife. He doesn't need cause. Traditionally, he didn't need a court. In many Islamic countries today, Muslim majority countries today, you still need to go to court. But traditionally, a man did not really need to have any cause or any reason for divorcing his wife. He could simply pronounce the statement that he divorces her 3 times, and they were technically divorced. A woman had a limited right of divorce. If a woman wanted to divorce her husband, usually she needed to have a cause, a reason. And different schools of Islamic law list sets of reasons with slight differentiations between them. So, for example, if a husband did not fulfill his obligations under the contract, obviously, that was a case, a reason for which she could sue for divorce. If her husband was insane, if he had a terrible and communicable illness, if he was a criminal, certainly if he decided not to practice Islam anymore, if he was abusive, if she feared him, even if he was impotent. These were all reasons for which a woman could sue for divorce. But she still had to go to the court. That's the difference. She had to have a reason. She had to go make her case before the court. And she had to actually sue for divorce in that particular case. There is also the possibility in Islamic law of a woman returning, if the husband agrees, returning her dowry in exchange for ending the marriage. In a sense, paying back this dowry in agreement, in exchange for her husband agreeing to divorce. But it's still not the absolute unilateral right that men had to divorce. So that is a distinction. But at the same time, while it does give men that unilateral right, it also provides a number of preventative measures to try to prevent the divorce from happening in the first place, and disincentives. I talked about the Quranic recommendation for arbitration. The Quran also states that if a man wants to divorce his wife, the way he's really supposed to do it chronically is he divorces her, they separate for a period of time, kind of cooling off period. And then they come back together and try to reconcile. And then if they can't, they separate again. And then they come back a third time. And after the third time, they can't reconcile, and so he a third time says, I divorce you, then the divorce is final. But again, there was supposed to be this period of time in between so that people, whatever argument or problems they were having would have time to perhaps resolve itself, and they could rethink what they were doing. The idea of the deferred mahar, the deferred dowry, was also a disincentive. A man might, have to come up with, depending on the contract, a large sum of money if he were to divorce his wife. But also it's important to think that divorce was irreversible, really, almost irreversible. So a man could not just divorce his wife and then a few months later say, changed my mind, let's get married again. And you couldn't do that in Islam. The only way a divorced couple could ever remarry would be if the divorced wife married another man. It had to be a full marriage. The marriage had to be consummated, and her second husband, freely divorced her. Then there was a possibility that her husband could remarry her again. But this was a great disincentive. You'd have to really think about this if you were a Muslim man. Think about the fact that there was no real possibility. The possibility of reconciliation or remarriage hinged on this very difficult requirement. So it was something to, to think about. Now, in Islamic law, as it developed, can I take your question 1 second? As it developed, certain schools of law allowed a man to pronounce these 3 statements of divorce, one after another. I divorce you, I divorce you, I divorce you, and that's it. But that is, of course, not the way that the Quran says that it should be. It's supposed to, the reason that you have to say it 3 times is precisely so that you can have these periods of waiting in between. Yes?
Why would he even allow remarriage even in that extreme situation when she marries again and divorces another guy? Why would they? I mean, it seems like the whole point of all this law around marriage is that they're trying to encourage families to stay stable.
Mm-hmm.
And that this whole elaborate process for divorce is really saying, well, you proved that you're a family that doesn't work.
Mm-hmm.
So why would they even allow that husband to remarry his wife even in that extreme case?
Well, perhaps the idea, I mean, again, I can't say absolutely, what the reasoning was about that, except that, it seems to me that this idea of having to go through these hoops, I mean, it's really almost impossible hoops if it's done properly, to remarry your wife would just, in a sense, be something that would give a man a certain pause. No matter how angry he was with his wife, he might stop and think. But maybe remarriage was the idea. Well, if she was divorced from the second wife, from the second husband, I mean, marriage in general is a good thing, and so if this is a possibility, then perhaps in that case, after this whole situation has taken place, that's a possibility. Yes. Yes. Yes.
If the woman sues for divorce, how does she come up with evidence for whatever her claim is that the husband is not providing or not fulfilling?
Well, it depends. Modern times it might be kind of easy. You sort of present receipts and different kinds of things that you need and so on. But yes, I mean, she did have to make her case that he wasn't providing adequately for her, that, she didn't have what, she really should be having, what was a basic minimum standard for being, clothed and fed and so on. Certainly any kind of clear violation of the contract was something that was, there you had a document right in front of you that was very clear. But, in other situations, yes, she would have to bring evidence, she would have to bring witnesses and this kind of thing, and it was something that the judge would have to decide.
I'm just thinking, I'm familiar with the cases that in 19th century Europe there were areas where divorce was allowed for periods of time, but it was very uncommon for women to initiate it because it was virtually impossible for them to come up with the evidence that was necessary.
It certainly, in certain cases, it definitely might have been very difficult to come up with the evidence. But let's say in a case, I mean, some of them were medical issues, right? Let's say impotence or having a certain kind of disease, that kind of thing might be something that, you could medically, that could be, you could have a medical witness that would give a kind of, testimony about that. So it was something that, would have been difficult. I mean, not all situations would have been provable, but these were reasons for which a woman could come and plead her case. And, and the judge would then decide between them whether this was a legitimate case or not.